In June 2025, Bass Pro Shops and Cabela's faced a proposed class action lawsuit in U.S. District Court in Utah, accusing them along with manufacturers, distributors, and the Archery Trade Association of conspiring through MAP policies to inflate archery product prices since 2014, violating antitrust laws. This case underscores a critical hurdle in protecting brand price integrity, that is, the legal ambiguity around MAP enforcement. Brand teams often grapple with confusing questions like, can warning emails count as coercion? Does add to cart pricing violate advertised price rules? The simple answer is yes, if you tell them how to advertise price, but this comes with conditions. But if you tell them what they must charge at checkout, you can cross into prohibited territory. Today, we are going to unpack that distinction, starting with a century-old legal principle that still guides MAP enforcement in the United States. This might sound technical, but understanding the boundary between setting a policy and forming an agreement is key to legally defending MAP enforcement. To begin, let's use a simple analogy. Imagine you own a coffee shop franchise. You can announce publicly, we will only supply coffee beans to stores that do not sell below a set price. That's a policy, a unilateral statement of how you choose to do business. But if you sit down with each store and ask them to sign a contract agreeing to keep price at a certain level, you created an agreement, and that can trigger antitrust scrutiny. In US law, the Colgate Doctrine makes the distinction very clear. It says a manufacturer can unilaterally set a policy and refuse to do business with retailers who violate it as long as there's no formal agreement or coercion involved. MAP lives in that space where you can announce your terms to the market without entering into formal contracts that dictate resale prices. Manufacturers maintain legal authority under US antitrust laws to announce unilateral minimum advertised price policies without retailer consent or coordination. Such policies state a minimum advertised price, example, advertise the X model headphones at no less than $399, which is applied independently by each brand directly to its retailers. In this case, retailers retain full discretion over final sale price at checkout or in cart, provided public advertisements comply with the stated flow. Antitrust violations arise when manufacturers or retailers engage in coordinated price restraints under Section 1 of the Sherman Act. Competing brands cross into horizontal price fixing by agreeing or uniform MAP levels such as brand A and brand B aligning on $399 at a trade event to protect margins. Trade associations inflate risk by issuing standardized MAP schedules for collective adoption, as alleged in the 2025 Bass Pro and Archery Trade Association lawsuit. Retailers policing each other through mutual reporting of violations further signal collusion. MAP is well understood in the US, but once you cross borders, the rules change significantly. In the US, MAP is generally supported as long as it remains a unilateral policy, not a contractual agreement. Enforcement is safer when applied uniformly with clear documentation of violations and consequences. In many EU countries and the UK, any attempt to influence resale prices, even through advertised pricing, can be treated as resale price maintenance or RPM. European competition laws tends to be stricter. Influencing what a reseller can or cannot charge may be seen as restricting competition. This often forces brands to lean on selective distribution systems, where resellers are chosen based on qualitative criteria, example service level, showroom experience, rather than price rules. In Canada and other markets, the legal approach can resemble the US model if the policy is clearly unilateral without coercion, but enforcement practices often vary. Some countries still treat resale price constraints with caution similar to the EU. The key takeaway for global brands is that you cannot transplant a US-style MAP policy directly into every market. You must tailor both policy language and enforcement approach to local legal norms. Protecting your brand depends on a MAP policy that is legally defensible. And that means It must be it must be applied consistently to all resellers. It must reflect the legal context of each market you operate in. Inconsistent enforcement or favoritism, where some resellers are treated differently, can be what triggers legal action more often than the policy itself. But here's the critical insight. A legally sound MAP policy is only half the battle. The real test comes when you enforce it, and that enforcement reveals a painful truth. Many brands have policies on paper but lack the distribution control to back them up. In our next session, we explore why your retail partners are quietly walking away. We call it the retailer's rebellion over pricing, and it's driven by the economics of undercutting, free riders, and eroding margins that no amount of legal documentation can fix without enforcement. Thank you.